Electrical and Mechanical University.
Your Honor, my name is Arthur Stern, and I'm the attorney for the appellant, Dr. Babu Jain. I'd like to reserve 3 minutes for rebuttal, if I can manage to be concise enough to do that. Dr. Jain is a professor at FAMU and has been teaching at FAMU since 1967. He became an associate professor with tenure in 1978, became a full professor with continued tenure in 1995, and in 1999 he decided that he would elect to join the drop program. And I assume this court is more familiar than I am with the drop program, so I won't waste my time explaining that, except for the comment that if one elects to participate in the drop program, a part of that election is to agree to terminate one's employment at a defined future date, which in this case was elected by Dr. Jain to be May 30th of 2003. Dr. Jain decided about 3 months before May of 2003 that because of a change in his situation, his personal financial situation, that he desired to remain at FAMU and to continue in his tenured position. And in March of 2003, therefore approximately 3 months prior to the time that his drop termination date would have occurred, he wrote a letter to the Dean of Arts and Sciences and said, "I wish to retain my position." The evidence at the hearing, and I believe this becomes crystal clear when one reads the decision of the administrative law judge, was absolutely unequivocal that this request on the part of Dr. Jain was accepted by the university. I hope that the court will agree with me in reading the recommended order of the administrative law judge that it was really a blistering opinion. It stated in so many unequivocal.
Assuming that's correct, let's go a little further. To entitle your client to attorney's fees, with some other things, more than direct attorney's fees, it requires a supporting allegation and a factual finding that the other party engaged in the litigation for an improper person. That's under 57.1055. Now no such finding was ever determined by the ALJ. Wouldn't we have to assume that issue is not preserved for this court to grant any relief to your client, and that he waived that by not seeking and making sure that determination was made?
With all due respect, Your Honor, I would take issue with a couple of points that you made. First of all, the applicable section is Section 57.105, which since 1999, when the statute was liberalized, imposes a completely different standard for the granting of attorney's fees, and the standard being whether the losing party or the losing party's attorney knew or should have known that a claim or defense was not supported by the material facts necessary to establish the claim or defense. And that was a change that was made in the statute. One of the arguments of the appellee here is that that's not the statute that should be applied here, but rather 120.595 should be applied. But 120.595 makes absolutely clear in one of the last provisions of 120.95 that it is not intended to supplant other statutes providing for attorney's fees, and it makes specific reference to 57.105.
Did you file any written request for fees under 57.105?
Yes, sir.
At what point in the proceeding?
The point in the proceedings in which it was filed with a specific reference to 57-105 was in a motion made to the administrative law judge within 15 days after the recommended order had been handed down by the administrative law judge. And that motion is a part of the record in this case. And Your Honor...
Is it your understanding that that's an acceptable way to do this in administrative proceedings?
Absolutely, Your Honor. And I would cite the court to the Supreme Court case, Florida Supreme Court case, which I failed to cite in my brief, but the Supreme Court case is Gans versus HZJ, which is 605.
And you submitted that as a late filed authority to the opposing counsel?
No, I didn't, Your Honor.
Then you can't use it here at oral argument then, because your opposing counsel hasn't had an opportunity to review the case.
All right, Your Honor. I might just point out, if I could, that that case states specifically that a litigant who is asserting 57.105 as a basis for attorney's fees does not only not have to assert that right before a judgment has been entered, but could not even be expected to assert that right before judgment is entered. And the court said it is extremely difficult, if not impossible.
Mr. Stern, I just told you, you can't rely on that case here at oral argument because you didn't supply the citation to your opposing counsel, and it would amount to sandbagging to use a case that your opposing counsel had no prior notice you intended to use.
Yes, Your Honor. Then I will not further refer. The case law, and this was a case that was cited in our brief, which is the GEL versus, let me get the citation or the correct name of that case. GEL versus Department of Environmental Protection says that where an administrative law judge has failed to properly consider a motion for attorney's fees pursuant to 57.105, a remand to the ALJ for that purpose is the proper course of action. And a motion was indeed made to the administrative law judge to evaluate, based upon its decision, whether an award of attorney's fees pursuant to 57.105 was proper. The appellee in this case, Your Honor, does not contest, and therefore I would suggest that we're not sandbagging the appellee. The appellee, in its responding brief, did not contest the fact that the administrative law judge retains jurisdiction for purposes of a motion to grant attorney's fees under 57.105. That was specifically conceded by the appellee in its argument, and therefore it did not, frankly, occur to me that it was necessary to provide further authority to rebut that argument, because the argument was not made.
Attorney fees in your petition for administrative relief filed in proceedings?
There was a request for attorney's fees in the proposed recommended order.
I understand that in your proposed recommended order. Was a request made for fees in the petition for administrative relief filed in the proceedings?
No, Judge Lewis, it was not, and I would submit that it would have been inappropriate at that point, because unlike a normal complaint in court where adverse action has already been taken, when the petition for relief is made, one is hoping, the petition is made not to the administrative law judge, but is made to the agency, in this case FAMU, so one would hope that the agency is going to favorably act upon that petition. It's only after the FAMU has not acted and a request for a hearing.
So it's your position that it's appropriate to make your first request for fees in the proposed order submitted by the party?
Yes, sir. Yes, sir. And in this case, the administrative law judge did not deny that petition. The administrative law judge simply stated in a footnote to its order that although the petitioner had made a request for attorney's fees in the proposed recommended order, that the petitioner had not cited the specific provision under which attorney's fees should be granted. And that's why within 15 days of the recommended order, we filed a motion and specifically for attorney's fees under that section. And
so in the proposal order where you requested attorney fees, there was no mention of any authority for the granting of the attorney fees?
Correct, Your Honor. Correct. That authority was set forth, namely Section 57.105, in the motion that was made within 15 days, which, according, and as I pointed out, that was not contested by the appellee in the appellee's brief. It's not contested that the ALJ retains jurisdiction for purposes of entertaining such a motion. Apparently, the ALJ did not feel that she retained jurisdiction because she didn't deny the motion. She simply didn't act upon the motion. And I submit that under the GEL case, it's appropriate for this court to remand for a consideration of that issue.
Did you try to bring it before the ALJ by calling in and seeking a hearing on the motion and forcing the ALJ's hand?
Well, that's not a part of the record, Judge, but in fact I did call the ALJ's assistant, who informed me that as far as, but the answer to your question is yes. Would you rather I not go further?
I'd rather you not go any further.
Okay.
Here, say testimony.
Okay.
Thank you.
There is no question, Your Honor, that the bar has been lowered insofar as the standard that needs to be shown under the statute as amended. And I specifically refer the court to paragraphs 38 and 39 of the ALJ's opinion, which indicates unequivocally that in all respects the FAMU had accepted in all kinds of ways.
Counsel, let's digress for a moment again. Your first request for fees was made in the proposed order you submitted.
Yes, sir.
Okay. In that proposed order, you didn't reference 120 or Chapter 57 as the basis or authority for granting fees.
Yes, sir. That is correct.
Okay. Thereafter, you filed a motion under Chapter 57 for fees.
Yes, sir.
Okay. Then the ALJ entered, in this case, her recommended order.
No, sir. It was the reverse order. The ALJ had entered her recommended order and did not accept or deny the request for attorney's fees. She simply indicated in a footnote that in the proposed recommended order, petitioner had not referenced what section of the Florida statutes petitioner was claiming attorney's fees under. And in turn, then, the petitioner filed its motion within 15 days under Rule 105, or 57-105. The appellee did not contest the continuing jurisdiction of the ALJ, but filed a response in which the appellee said it's not 57-105, it's 120.595, and we believe that's completely wrong.
Did the ALJ make a specific finding in the recommended order that the agency, in this case FAMU, knew or should have known that a claim or defense when initially presented was not supported by the material facts necessary to establish the claim or defense, or would not be supported by the application of the then existing law to these material facts as set forth in Section 57?
Did the ALJ make
that specific and express finding in the recommended order?
No, Your Honor. because the ALJ simply did not decide on the issue. The ALJ simply said in the recommended order, in a footnote, petitioner in his proposed recommended order requested to be reimbursed for attorney's fees. Petitioner does not cite to the authority under which he makes his request. That was the only indication in the recommended order, and that's what prompted the motion to the ALJ within 15 days of the time that recommended order was, and a copy obviously was sent to FAMU, which responded not by saying that the ALJ lacked jurisdiction. In fact, in the appellee's brief to this court, the appellee has acknowledged that the ALJ had jurisdiction pursuant to GEL and other cases which I'm not able to cite to the court about the continuing jurisdiction. So that is not denied. The only position that was taken by the appellee was that rather than 12057, or excuse me, 57.105, that another section of the statute should apply, and that other section.
Mr. Stern, you've exceeded the time allotted for your argument. We'll give you 1 minute for rebuttal, even though you're already over your time. And we'll allow opposing counsel an extra minute should she feel she needs it in her argument.
Thank you, Your Honor.
May it please the court. My name is Antonia Rowe. I represent Florida A&M University, appellee in this case. The agency correctly adopted the administrative law judge's recommended order and correctly ruled on the exceptions filed by both parties to the recommended order of the administrative law judge. Chapter 120 of the Florida statute specifically provides for instances in which attorney's fees and costs should be awarded to a prevailing party in a 120.57 hearing. Section 120.595 of the Florida statutes provides that attorney's fees and costs to the prevailing party only where the non-prevailing party has been determined by the administrative law judge to have participated in the proceeding for an improper purpose.
Ms. Rowe, Mr. Stern said he's not looking for fees under that provision. He's looking for fees under 57.105. Is it your position that 57.105 simply cannot be applied in administrative proceedings?
No, Your Honor, it is not. It is our position that because Chapter 120 provides a provision for attorney's fees, then that provision should govern. In addressing Section 57.105 of the Florida statutes, there must be a finding by the court that the losing party knew or should have known that a claim or defense, when initially presented to the court or at any time before trial, was not supported by the material facts necessary to establish the claim or defense, or would not be supported by the application of then existing law to these material facts. In this case, the
opposing counsel said that he filed a motion which he maintains was proper under the procedures applied in this proceeding. That the ALJ refused to rule on it, and it should have been ruled upon. What is your response to that?
Our position is that the motion was filed at the time that the exceptions were filed, and as such, the statutes provide that the agency has the authority to rule on the exceptions, assuming that is why the administrative law judge did not rule on that motion, and the motion was not filed timely, and that it was filed after the recommended order had been issued, and it then fell to the agency to issue its final order and respond to the exceptions.
So at that point in time, your position is that the ALJ did not have jurisdiction to enter an award of attorney's fees?
Our position is that under GEL, based on that case, the administrative law judge did have the jurisdiction. However, by not granting that motion, that she effectively denied it by not making a ruling.
Well, but the agency went ahead and addressed the request for attorney's fees in the final order.
Right.
And said, you're not entitled to attorney's fees because you requested them under the wrong provision.
Right.
Well, if we conclude that attorney's fees might be applicable under 57-105, given proof of the proper requirements, what do? Do we send this back?
Yes, Your Honor, you would remand it back.
Do you agree with the appellant that the motion for fees pursuant to section 57 was timely filed after the recommended order was entered in this case?
No, Your Honor, I do not.
When should it have been filed, assuming that there's authority for awarding fees under Chapter 57 in an administrative proceeding? When should a motion be filed?
It should have been filed either during the proceedings, during the hearing, or at the time that the administrative law judge issued her order and there was the proposed recommended order and the authority set forth in that order so that the administrative law judge could make a determination.
If the agency, and the agency in this case is the president of Florida A&M, I take it, essentially. If the agency didn't think that the request for attorney's fees had been timely filed, why didn't it say that instead of saying you filed it under the wrong statute?
Because it is the agency's position that 120.595 governs and not.
So the agency really did address the merits of the request for attorney's fees and denied them based on the request having been made under an improper statutory provision.
Right, pursuant
not for lack of jurisdiction, or not because the motion was untimely.
The agency made the decision based upon Section 120.57, subparagraph 1K, which gives the agency authority to rule on exceptions to the recommended order, and based on the motion being filed at the same time with the exceptions, the agency took that motion as a part of the exceptions and made a ruling on the exception.
So you concede that the agency had the power to consider and rule on the request for attorney's fees?
Yes.
Okay.
Counselor, in reference to Judge Russell's question again, under Chapter 120, the agency has the power to rule on a request for attorney fees. Now, in reference to Chapter 57 Florida statutes, does an agency have the power to rule on a motion filed pursuant to Chapter 57 Florida statutes for fees?
No, Your Honor, that has to be a finding made by the court.
Thank you.
Well, wouldn't the way to do that be for the agency if it concluded that attorney's fees might be available to remand to the ALJ for an evidentiary hearing?
Because there was no specific finding by the court as required under Section 57.105, the agency did not remand to the administrative law judge.
But he filed a motion, and it wasn't his fault that he didn't get a ruling on it. Is that correct?
That is correct.
Well, but in fact, he did get a ruling by the agency, didn't he? The agency ruled on this. The ALJ just never ruled on it.
Right, the ALJ did not rule on this.
The agency denied it on the merits. You've already agreed with that, haven't you?
Right. Again, referring back to Section 57.105, this court in Langford v. Ferreira, Judge Browning, you wrote that opinion, in interpreting Section 57.105, stated that as a prerequisite to an award of attorney's fees pursuant to 57.105, the trial court must find a complete absence of a judiciable issue of law or fact raised by the losing party. Again, that finding was not made in this case. In addition, in Wendy's of Northeast Florida v. Vandergrift, again written by Judge Browning, this court determined that in determining an entitlement to a statutory attorney's fees, frivolousness is determined when the claim or defense is initially filed And if the claim or defense is not initially frivolous, then the court must determine whether the claim or defense became frivolous after the suit has been filed. In addition, this court stated that the central purpose of Section 57.105 is and always has been to deter meritless filings and thus streamline the administration of the courts.
Mr. Rose, those cases will involve where the issue is adjudicated by some fact finder. Apparently, we don't have that here, do we?
Yes, Your Honor.
Has anybody ever just looked at the mechanics of this, the fact finder, and said, there's no justiciable issue here?
No, Your Honor. I would also like to address the issue of the summer employment for the appellant. Appellant is a 9-month tenured faculty employee, thus he is only guaranteed employment for a 9-month period of each year. FAMU cannot guarantee employment beyond the tenure status because the summer employment is based upon the courses that are offered, the anticipated student enrollment, in addition to the employee's area of academia. If the university would have to extend the summer employment to all of its 9-month faculty employees, there is the possibility, the strong possibility that all the course offerings would not, all the courses would not be offered. In addition, the student enrollment will not be sufficient to justify the financial burden borne by the university by employing its 9-month employees. In addition, all state universities have a 9-month or a 12-month faculty employee contract, and making a ruling that the agency would have to grant summer employment for this period would impact the entire state university system, being that it would be used for other 9-month employees would then go back and request a required summer employment, being then a 12-month contract employment.
Counsel for the appellant in issue 3 seeks prejudgment or post-judgment interest in this case. Why isn't the appellant entitled to a prejudgment or post-judgment interest in this case?
In this case, the administrative law judge did not find that there was a breach of the contract. Instead, the administrative law judge concluded that FAMU attempted to unilaterally rescind the contracts, and under a rescission normally would return the parties to their pre-contractual positions, meaning that we would be at the point where the appellant would be requesting summer employment and the university would then be advising or would then be reviewing that request. And in Knowles versus CIT, this court determined that the complainant must prove by a preponderance of the evidence the existence of a contract, a breach of that contract, and then damages flowing from that breach. The administrative law judge did find the existence of a contract. However, she found there was an attempt to rescind the contract, not a breach of the contract, thus no damages flowing from a breach. In conclusion, the university respectfully requests that the final order of the agency be affirmed.
Thank you. Mr. Stern?
Thank you, Your Honor. Just very briefly, the brief of the appellee in this case, and I quote, said, based on GEL, the ALJ in this case retained jurisdiction to consider a motion for attorney's fees if one was made. And as a part of the record, the appellant filed a document within 15 days called Exceptions to Recommended Order and Motion to Administrative Law Judge for Award of Attorney's Fees pursuant to Florida Statutes 57-105. I will And the administrative judge had not found against. The administrative judge had just not passed on the issue in the recommended order. The other
Part of the problem, Mr. Stern, might have been that you joined these two very different things together in one paper. And in fairness to the ALJ, she may just not have recognized that there was a motion included with your exceptions.
Right. And that's why in response to Judge Browning, I said I followed up. I wanted to make one comment to one other thing that, if I may be permitted, that the appellee...
Very briefly.
All right. On the question of continued employment over the summer, when back pay is awarded, very few parties in this world, in the state of Florida, have a vested contract to work. What is the question is not whether Dr. Jain's tenure involved summer employment. The question is, what did the ALJ mean by reinstating him with all back salary? He had been employed during the summer for 30 consecutive years. And the question then is, what was contemplated in the ordinary course between the parties, and therefore what did the ALJ mean?
Counsel, just one question. You quoted, I guess, from an order where the ALJ specifically retained jurisdiction for purposes of awarding fees.
Yes, sir.
Must the ALJ retain jurisdiction for purposes of awarding fees after a recommended order has been entered?
Your Honor, the cases, you routinely state that where the ALJ has that jurisdiction and should consider a motion. The one case that I cited in the brief was the GEL case, and there are some other cases that were also cited in my brief that remanded to the ALJ
So it's your position that the ALJ retains jurisdiction after entering the recommended order to rule on the subsequently filed motion for fees without a retention of jurisdiction in the recommended order? Absolutely,
absolutely, Your Honor. The cases show that there is no requirement.
That's precisely the same as the situation in civil cases, isn't it?
Yes, sir. And 57105, specific by the amendment passed by the legislature in 2003, specifically said that all of its provisions would apply equally to administrative proceedings. Prior to 2003, the provision had only applied to civil proceedings, not administrative proceedings.
Thank you. Thank you both. Last case on the calendar today is Blair